This is David Olshan of Nevada Legal Services. This is another in our series of substantive videos, this one concerning eviction and bankruptcy. So, saving your residential dwelling in a Chapter 7 or 13, summarizing it quickly, if you have a judgment for possession, it's still possible, but only if the landlord proceeded under the plenary process, which is not the summary eviction process. If it's before judgment, you have a much better chance. The landlord cannot start the eviction unless the stay is lifted. Of course, the landlord may always proceed with an eviction if the eviction is based on illegal drug use or endangerment of the property. If judgment is entered, there are some specifics that you need to stop the eviction. It must be a non-payment eviction and your lease has not expired. If this situation does apply to you, and it's very rare, then you can avoid the eviction if you file a bankruptcy petition certified to the bankruptcy court that the law allows you to cure the default, which it does, and then you send this notice to the landlord and you deposit 1 month's rent with the bankruptcy clerk. Then you pay off all the arrears within 30 days. If you can do that, again, it's rare, you can avoid the eviction if a judgment of restitution is already entered. Again, this is theoretical, usually not practical. It rarely happens. So it's vital that you file your bankruptcy petition before the landlord begins the eviction case. In Nevada, a tenant has to pay rent when due, and the landlord may serve a 7-day pay rent or quit anytime after it's due. So if your rent is due the first of the month, the landlord can give you a 7-day notice. And that's when you have to file your bankruptcy petition within those 7 days if you want to have the best chance of avoiding the eviction. You can file a skeletal Chapter 7 petition, so contact us right away if that's something you want to do. There's no grace period for paying rent in Nevada. If you want to stop an eviction by filing a bankruptcy petition, you should do that before the landlord starts the eviction process. If you file your bankruptcy petition, the automatic stay is invoked and the landlord can't proceed without lifting the automatic stay. You also must be able to continue to pay the rent after you file, or the landlord can start the eviction process after the bankruptcy court issues the discharge. So during this time, the landlord has a choice between negotiating with you and hiring an attorney to lift the stay. So that gives you an opportunity to negotiate with the landlord, and that's one of the benefits of filing for bankruptcy. We also want people to know that if the landlord is going to allege illegal use of a controlled substance or endangerment of property, the landlord can file certification with the bankruptcy court and proceed with the eviction unless you object. So if those are the allegations, even if it really is about non-payment, the landlord could possibly manufacture these allegations. Just keep that in mind. If the landlord does file certification with the court and you do not object, the landlord can proceed with the eviction. So usually if a landlord does file a motion to lift the stay, the landlord will succeed because your lease has no value for the estate. The exception is if you have a public housing voucher, or you're in a rent-controlled jurisdiction, which isn't in Nevada, you may have an argument. If you can continue to pay rent and your lease has value, or you can provide adequate protection in the form of cash, then you might prevail and the court may not lift the stay, but almost always the court will lift the automatic stay if the landlord files a motion to lift the stay. One thing to keep in mind, in Schedule G, you want to assume your lease and you want to fill out your Form 108 Statement of Intention and send it to the landlord. If this is confusing, contact us at Nevada Legal Services and we can provide some legal advice and possibly representation in a bankruptcy. We are Nevada Legal Services. If you want help with an eviction or a bankruptcy, please contact us in Southern Nevada, 866-432-0404. In Reno or Northern Nevada, 800-323-8666. We provide free legal assistance, and we will have more substantive law videos in the near future.